Hello guys, welcome to the fifth session of the course. So today we will study about a few essential limitations to copyright protection. Alright, without wasting any time, let us jump right onto the basic topic. Now, limitations tell us what we can legally use without asking for copyright permissions. So of course we know that copyright gives creators rights over their work, but it doesn't mean that nobody else can ever use that stuff. So there are some built-in exceptions in the law, especially for things like either education, research, reviews, news, and even memes. Now, Section 52 of Indian Copyright Act deals with the elements of limitations. Okay, so the first limitation is that of fair dealing. So in India, you can use someone else's work without permission if it's either for private or personal use, which can include things like research or maybe criticism or review of certain topics, or even reporting current events. So, for example, if you are quoting lines from a book in a book review, then it is totally fine. You don't need to ask for copyright. Or if you are reporting news or showing a clip, then it is totally okay. But if you are downloading an entire album from Telegram for research purposes, then that is not fine. And it can be considered as copyright infringement. Now, a relevant case when we talk about fair dealing is that of Civic Chandran versus Amini Amma of 1996. So what happened was, Thopil Bhasi, who is author of a Malayalam play which is in English known as You Made Me a Communist, it is a famous social drama that surrounded the communist ideology. Now, Civic Chandran, who is a social critic and playwright, he created a counter drama which was in English called as Whom Did You Make a Communist? His play was meant to critique the original one in form of satire. So he tried to show how communism in his view had drifted away from its original ideals. So Civic Chandran used characters and themes and a similar structure from the original play. Now the original author sued him, claiming copyright infringement. And this made a landmark ruling because Kerala High Court reinforced the fact that fair dealing allows for use of copyrighted material if the purpose is criticism, review, or academic analysis. So here Civic Chandran's use of parts of original play was not infringement because he did not completely copy the entire play to use it, but he instead chose to comment on the play. And the new work has a critical and transformative purpose. So it is form of a political and ideological critique, not commercial exploitation. Now, one more example would be, imagine if you know somebody writes a book praising capitalism entirely, and you write another book pointing out the flaws in their argument and you quote them a few times to prove your point. Now that is fair dealing. But if you just reprint their entire book and say, here's what I disagree with, that is not fair dealing, that is completely copying. Now, the second exception to copyright protection is that of educational use. So you can use copyrighted works during classroom teaching, you can use excerpts in exam papers or even in student assignments. Or you can perform plays, music or poetry in school as long as it is not commercial. So if you're performing a scene from a Shakespeare play, then that is not copyright infringement. Or if you are printing a few pages of a textbook for homework, that is also okay. But if you are scanning and uploading an entire textbook to class WhatsApp group, that is where copyright infringement takes place. So a very famous example here is that of DU photocopy case, which is also known as the Rameshwari photocopy case of 2015. So Delhi University allowed a shop to photocopy portions of textbooks for its course pack and publishers sued them. But Delhi High Court maintained that it is legal because it was used for academic use and not for commercial resale. Now, third exception is that, of course, with regards to judicial or legislative use. So work can be freely used without any copyright request in areas like judicial proceedings. So when you're producing documents in court, you don't need to gain prior permission from the owners of those work. Or if you are reporting judgments, then newspapers can also publish stripping court judgments without having to ask. As we talked about before, that government documents are also not copyrighted. Then you can also publish the details of laws or parliamentary debates or official reports or comments or notifications without any prior request. But understand one thing, So let's talk about a case here, which was the Eastern Book Company versus DP Mozart case of 2008. So their Supreme Court ruled out that judgments themselves are public documents and they are not protected by copyright. But at the same time, the publisher's head notes or editorial notes or cross references are protectable because they require a certain level of skill and labor. Now, the fourth exception is that of libraries and archives. So, libraries and archives have special rights and they can make copies of a book for preservation. For example, let's say if there is an old Sanskrit manuscript which is falling apart with time, then the library can digitize it to preserve knowledge for the future generations. Or they can supply the work to researchers for studying or researching, of course. And they can also replace damaged copies if personals are out of print. And of course, this is very important because without this, rare works would disappear forever if they are not preserved on time, or if they are not digitized, or if no extra copies are made. Now, of course, the fifth exception is that of public domain. So, we have talked about public domain before. So, of course, as we know, copyrights are time bound. So, usually they are preserved until 60 years after the author's death. And once that term ends, then it becomes public property, which means that anyone can freely use it, adapt it, reproduce it, anything. And they don't need to ask for prior permission. So, yeah, that one I have already talked about before. Now, the last limitation is regarding people with print disabilities. So, Section 52(1)(zb) ensures that adaptation of works into formats like Braille, audiobook, or digital accessible copies can be made without asking for prior permission. And of course, the only one condition for this is that it should be non-commercial and it should only be used for accessibility instead of profit, of course. And this was added after India signed the Marrakesh Treaty of 2013. So this treaty focused on access to knowledge for the visually impaired population. Okay, I hope this was clear. So today we learned about exceptions against copyright protection. In the next session, we will learn about 3 types of remedies, which is civil, criminal, and administrative. After that, we will understand how to administer copyright in India. Okay, great. So thank you so much for tuning into today's session. My name is Bhargavi and this is Vaquill.